Welcome. My name's Jayne Adams, and I'm doing for you here one of our on-demand short webinars on, in this case, Fatal Accidents Act claims. Anybody who's heard me speak before will have heard some of what I have to say, because quite frankly, not a lot has changed in this area of the law. But what I'm intending to do is to give you a sort of back to basics approach at how to look at these claims and the challenges that you might face with them. But I'm going to start by saying that the Fatal Accident Act is entirely a creature of statute, and it is now outdated. That was a point made repeatedly by the previous House of Lords and by the Supreme Court, and very succinctly by Lord Sumption in Cox. I put that on the screen at the beginning. I'm not going to keep going back to that theme, but he points out, as anybody who looks at this properly will see, that it is in need of a massive overhaul. But because it's a creature of statute, that needs to be done by the government of whatever colour, and at the moment there seems to be no political appetite for doing so. But it remains one area of the law that does indeed quite frequently overcompensate, in that the dependency claim, when the rules of the Fatal Accident Act are followed, involves paying more than a dependent might actually have lost. And I ask you to keep that in mind when we go through the heads of claim. Now, the Law Reform Miscellaneous Provisions Act 1934, that basically deals with any action which the deceased would have been able to bring on his or her own account for the benefit of the estate. So it doesn't include any claims for loss of income in respect of any period after death, but it does deal with all the losses before. The Fatal Accidents Act arises directly from the death of the deceased and deals with losses to the deceased dependents. Now, that might be to state the obvious, but it's the important principle to remember. Now, law reform generally is going to be damages for pain and suffering up to the date of death, which of course encompasses a wide range depending on the circumstances of death. It includes loss of earnings, which are calculated in exactly the same way as any other personal injury claim, and it includes funeral expenses. Now, generally, that does not include the cost of the wake, the cost of a memorial service, or probate costs. There are authorities either way, but generally speaking, that's the basis upon which certainly I always approach these cases, and usually effectively. Remember the Limitation Act, Section 12. So, a claim arises under the Fatal Accidents Act for any period up to 3 years since the date of death, as long as the deceased was not already out of time or had already settled their own claim in their lifetime. There is a confusion, quite frankly, between Section 12 and Section 33, in that Section 12.1 appears to rule out any discretion under Section 33, whereas Section 33 says the other way around. There is no easy answer to it, and I notice that the authors of Kemp and Kemp say they don't know the answer either, but the safest thing to do if you're a claimant bringing a claim is to make sure that you bring it within 3 years of the date of death or the date of knowledge of the dependents. You cannot rely on the date of knowledge of the deceased. So, what does the Fatal Accidents Act do? Well, it provides bereavement damages, claim for the loss of income and services dependency, and again, funeral expenses. But I've just referred to the 1934 Act. Of course, you can't have double recovery. Bereavement damages, there are a very limited number of classes of people who can claim, even though the Supreme Court has had something to say about that too. But as things presently stand, the only people who can get bereavement damages are spouses and civil partners in respect of their spouse or partner, and parents in relation to the death of an unmarried minor child. Because of that, and I think because of that, there have grown up a whole number of cases about what is called loss of love and affection. Now, Regan and Williamson really deals with children, and it is common in relation to minor children because they can't claim bereavement award for their parents. It's only the other way around. Regan and Williamson is an award, it's an emotional award for loss of love and affection of a parent. In relation to partners or spouses, there is still the attempt to say, oh, there should be loss of love and affection. But actually, if you follow the authorities, Moss and Grant and McGill all deal with this. What it really is, insofar as it's awarded, is compensation of the inconvenience of having to go and get commercially what a partner might just have done, DIY, for example. And they are very modest awards indeed. Very limited head of damage, not something to spend a lot of time worrying about. Loss of dependency inevitably is the big part of any such claim. Now, there is a wide range of potential dependents, far greater than can receive a bereavement award. And if you're for the claimant, important thing to remember is there is only one claim. So you have to identify all the potential defendants from the outset. And in the circumstances of modern family life, with split families, with potential different partners, or one partner who's still married but not divorced whilst the deceased lives with another partner, it all adds up to potential tension. But you've got to make sure you've identified all those potential dependents from the outset, because there is only one claim to be divided, as I've said already. And also from a defendant point of view, you want to know, you want to be certain, or certain as you can, that this claim is done and dusted once you've settled it, and there's not going to be another dependent coming out of the woodwork. It's more of a problem for claimants than it is for defendants, though, for the reasons I've already said. So what about spouses and ex-spouses? Well, of course, it is one of the enigmas of the statute that spouses and ex-spouses continue to have claims when cohabitees do not necessarily. Spouses always have a claim if dependency factually can be made out, even if they've married after the tort that gave rise to the death. That's Phillips. Haynes and South East Coast Ambulance Service and CC and TD are two cases really giving examples of how the court approaches a couple who are separated or divorced. Now, in Haynes, the couple had divorced, but later had got back together, and by the time of the death of the deceased were living together again and had intended to remarry. Now, in those circumstances, the dependency was allowed, but based on a percentage chance of that reconciliation lasting. In CC and TD, it was quite frankly, it seems to me, a trial. The wife had left. Her husband was having an affair which continued. Wife had no contact with the husband, was making her own way, but once he was killed, insisted that in fact they would have been reconciled, and somewhat unsurprisingly, the court wasn't having that. So again, it was dealt with on a percentage chance, but a very, very small one. So factually, that's how the court is going to look at it. Cohabitees. Again, one might think this is all rather an old-fashioned way of looking at it, but it needs to be a couple who have lived in the same household, and the wording is husband and wife, civil partners obviously been added by statute latterly, but they have to have been living in the same household as a couple for at least 2 years immediately prior to death. And Copti is quite a difficult case because there the couple had not been living in the same household for 2 years, even though the claimant was pregnant with the child of the deceased, and everything was pointing to the fact that they were going to make a life together. But because they hadn't been living together for 2 years, no dependency arose. Remember also that Section 13F excludes the children of cohabitees. So children are only regarded as children of the family for a dependency basis if the deceased was married to the living claimant parent. Now, one can think of endless examples now of, again, modern families where it's a long-term relationship and one partner has taken over care of the children of another. But if they've never married, those children are not entitled to compensation under the wording of the Act. Similarly, the court under Section 3.4 is asked to take into account the fact that the dependent cohabitee has no enforceable right to financial support as a result of their living together. So if a couple is together and never married, but they've been together for more than 2 years, the court can still take into account that that relationship might have ended and there is no enforceable right to financial support. Seems to me there that when we have the opposing problem in relation to somebody who had married, that the court can't take into account the prospect of remarriage, but in relation to cohabiting couples, the court can determine that it wasn't a stable relationship, that there are a degree of double standards. Again, why I say it's an outdated act now, but this is how we have to apply it. The most difficult part of any Fatal Accidents Act claim is financial dependency. But don't let that scare you. It is very, very fact specific. There are a number of ways in which the court can interpret the facts, and ultimately what one needs with a degree of experience is to stand back and say, where are the sympathies of the court likely to lie? Because as long as what the court has done is taken a reasonable approach on the facts to the quantification of the dependency, the appellate courts are highly unlikely to intervene. Now, if you have a couple or a deceased who is in what I would call ordinary employment, it's not particularly difficult. And of course, the vast majority of families are where one or both partners, mostly these days, both partners are in employment. So the starting point is Harris and Empress Motors, which is the determination that for a dependency claim, the convention is to assume that the deceased's income would be a third for their own use and 2/3 for their own living expenses and their partner's living expenses. Now, the reason for Carrad and Comex is to modify that when the claimant partner or the partner is working also. So the convention is when you're dealing with a couple alone, you take both salaries, you take 2/3 of that, and then you deduct the living partner's salary to get the dependency. And the same calculation, but 75% when dealing with dependent children. Now, it's a convention that actually is used surprisingly often. There can always be a move to say, actually, this particular family was either very short of money or very wealthy, so that the convention doesn't apply. But if that is going to be the approach, whether you're for the claimant or the defendant, you really must have all the financial information. So if I'm acting in those circumstances, I want to see all the bank statements, any savings, pension provision, everything that enables you to see whether this family really is outside of the ordinary. And again, if you have somebody very wealthy, and I have had cases of this nature, where the deceased, I have to say usually male, spends an awful lot of money on their own hobbies and provides less to their spouse, then the argument can work the other way. But generally speaking, the rule of thumb is the convention. Now, it's obviously quite a while ago, but what it did was change the basis of the calculation. Previously, multiply went from date of death, obviously led to injustice. I don't need to go back to the circumstances of that. But now what one takes is the life expectancy of the deceased from the date of death, but for whatever the accident or tort that led to death was. It is really important, actually, to make sure that your evidence on this is good, because if there are a number of intervening or comorbidities and life expectancy is less than normal, makes a big difference to the value of the claim, and likewise the other way around. So what you want to look at is life expectancy, and very often you might need life expectancy evidence if there's a reason to think that somebody's life expectancy is not average. You want to look at the length of working life, these days being put higher and higher. I think when I first started, everybody was working to the idea that we'd all retire at 55, which all seems something of a joke now, but certainly it's not unusual at all for claimants to say the deceased would have worked at least till age 70. Again, very fact dependent. Then we look at the education period of any dependent children, although I don't need to point out that quite often in families these days, adult children are continuing to live at home due to the cost of living expenses. That, again, that is a factual point. And then apply multipliers and multiplicands. So as I say, in circumstances where somebody has a normal employed career, that's not that difficult. Now, courts can take into account prospects of promotion, but it's fixed at the point of death. So you look at the point of death at what a career might have been, and then what the percentage chance of achieving that would be. So past losses are based on what the position was at the time of death. Future losses are dependent on whether there was a likelihood of promotion. And for example, if you've got a couple where the wife was on maternity leave or taking care to look after young children, whether she would actually have gone back to work, or he, if they worked the other way around. But what you have to do is look at point of death at what the intention of the family was going forward, and then apply that. Where it becomes much more difficult and interesting is in relation to what we call the wealth creation cases. Now, I've put O'Loughlin Wealth Ambulance Service and Williams and Ricks and Paramount Shop Fitting there, just like that, because I think if you're dealing with this type of wealth creation claim, those are the cases it's important that you read. Now, there is a thread running through them, but there is a different approach, which comes back to the point I made, that it all depends on the facts. Every case is fact specific, and the way in which the court wants to interpret it. Now, in O'Loughlin, the deceased had basically built up a property portfolio. That's something I actually see quite often, particularly people who've been in the construction trade, who then later in life go on to have sometimes very successful careers in this area. Now, so Mr. O'Loughlin had built up a decent property portfolio from which his wife benefited. Once he died, she didn't have the nous or the know-how to develop it. And indeed, although she'd got the assets, she sold some of them to live off. Now, the court in that case determined that the dependency was on a replacement, somebody equivalent to her husband, to be able to run the property portfolio. So the dependency was the cost of employing somebody to do what her husband had done. Now, Williams and Welsh Ambulance Service is a case of somebody who was a director of a company that they set up and ran themselves very successfully. And after death, the sons of the children of the family continued to run it. So the business was still there. The family was still running it, and the wife was still receiving profits from it. But the children had been massively overpaid for what they did, and the court's view was that the driving force behind it was the deceased, and what the dependency was, again, the cost of employing somebody to run the business in the way that the deceased had done. Now, Ricks and Paramount Shop Fitting Company Limited is an opposite example of that. So again, very successful deceased who built up his own business in which his two sons worked. In both cases, wife had shares in the business and was paid a salary, but didn't actually do anything. It was a tax, but a legal tax provision, and nothing turns on that. So with Ricks, in fact, after death of the deceased, the family continued running the business very successfully. Profits increased, and so the family were actually no worse off. But the court didn't accept that. It said it fixed at the point of death, and actually at the point of death, it was the father who was the wealth creator. The family had lost that they were entitled to look at the profits he would have generated because he was the driving force behind the business and award dependency based on that. It's a very harsh decision for the defendant, but leave to the Supreme Court was denied. And I think this is part, without expressing a view one way or another, there's a way of looking at the facts in each of them. This is part of the reason that if we go back, albeit it predated, to Lord Sumption's view in Cox, there is a risk in Fatal Accidents Act claims for overcompensating. But if we employ the rules strictly, that's what happens on occasions. I will stand back and say the reason there are really only a few cases dealing with wealth management is because both sides of this argument do understand the risks. And more than anything, that's what leads to sensible settlements, in fact, because one can never be sure what a court is going to do. And one has to use a degree of experience to work out what really is the right result. So, as I say, whenever you've got created wealth, self-employed or company director, and then the other point that comes up now, often an unconventional pension provision because of people choosing to invest, whether it's in property or in stocks and shares themselves, rather than a standard pension, then again, you've got to look about how that is going to play out into the future. It's really the same point as I've just dealt with in O'Loughlin, Williams and Ricks, but it needs investigation and quite often accountancy evidence. Adult children, it's very often claimed that adult children would have been dependent, for example, cost of weddings, deposits for houses, etc. It's a very fact-specific point. If a family have got no real savings, they're just living on their earnings, as most families do, and there is no spare money, that's already taken account in relation to dependency. So the standard 2/3, 1/3, or 75% dependency. It's only really, an AB and KL was a case of divorced parents, where the children were adults, so no longer had maintenance or anything like that. Now, in those circumstances, living in separate households, the court accepted a low-level notional sum for a contribution to weddings, a contribution to a deposit for a house. But in the vast majority of cases, unless there's obvious money from which that could come, it's a head of damage to be put carefully for a claimant and pushed back against for a defendant. Remember, you can't take into account benefit arising from death. And in the wealth creation cases, that actually leads to quite an argument. Now, matter of common sense, perfectly sensible that the law and the courts want to encourage people being responsible with their money. So insurance policies, life assurance, investment in pension, that is to be encouraged. So anything that arises from that is not to be taken into account. So if you have a widow, for example, who's receiving a widow's pension or had the mortgage paid off from a life assurance policy, you ignore it. The difficulty is when you have capital assets, and I come back to the property portfolio, for example. If there are capital assets, which is, as the courts describe, static, so in other words, they're just assets that don't need a driving input from the deceased from which the family benefit, and those assets remain there, then that is not taken into account for the purposes of a dependency. So if you take Mr. O'Loughlin, for example, if there's a property portfolio where the property is just bought but it's run by a managing agent, it makes no difference post-death to pre-death. That is not taken into account. Again, I'm sorry I keep saying this though, but very fact dependent. And then we have dependency on services. Years ago, this was always just seen as DIY gardening and decorating, or usually, and it is very outdated and sexist, there's no getting away from it. Most of the authorities are wives running the household. Now, though, there is an increasing number of cases dealing with care, and particularly what I come across quite frequently now is one partner who was looking after another with serious health difficulties or with dementia, for example. And when the healthy partner dies, there is a very large potential for services claim there, in respect of which you'll need both medical advice, life expectancy advice, and indeed very often care expert advice as to how best it would be provided. And whatever side of the fence you are on that, whether you're for claimant or defendant, it's important to be realistic about it. Geriatric evidence is very often required to deal with life expectancy of somebody with dementia. And also for the need to take into account that however willing and caring a spouse is in terms of looking after their spouse with dementia, the time comes in every caring family when that is a burden too much. And the only circumstance there is residential care. And it's important that that's properly dated and investigated. Incredibly sad, I'm afraid, incredibly increasing in terms of the number of such cases we're all going to encounter. And then there are other services, whether it's dressed up as grandparents picking their grandchildren up from school, whether it's older parents providing DIY activity for their children, their adult children. It's all a matter of fact and feel, but the potential for such claims are there. And then I come finally to two conflicting cases. Dr. Rupa Singh was a case of a claimant doctor working in the UK who, when her husband died, simply could not manage childcare. And so she went back to Sri Lanka, so she got family support, but inevitably there earned less. So what was claimed was the reduction in earnings for her for going back to her home, well, not her home, but going back to her country of birth where she got family support in order to care for the children. Now, the court there did not allow that reduction in income. They said that was an independent loss of income, which stood free of a dependency claim. Now, compare that with Witham and Steve Hill. That was a case of a couple who were fostering, intending to adopt 2 children, where the wife had a good career and the husband decided to stay at home and provide the caring facilities for the foster children. He very sadly died of mesothelioma, and the wife could not continue with her career and she gave up to care for the children. Because they're foster children, and I said earlier in this lecture that there's a very limited number of circumstances in which children are looked at, because they were foster children, they didn't qualify for dependency. They weren't children of blood, and they weren't the children of one partner. they were foster children. In that case, what was claimed, what was the loss of income of the wife. But in fact, what had really been lost was the dependency of the children on the father to provide the care for them, and that couldn't be recovered. So the court, in my view, manipulated that and said that really what had been lost was the whole family had lost the services of the father, and that should be measured not by the wife's earnings, but by the commercial cost of the father providing care for the whole family. Again, that went on appeal, just as Rick's. Court of Appeal upheld it because there was a reasoned basis for the approach by the judge. In fact, in that case, by the time it came to the Court of Appeal, the foster children had been removed from the equation, and what happened thereafter, we don't know. But those are two cases in which you can see the court will manipulate the facts and the way in which damages can be awarded to suit the scenario. Thank you. So please don't think I've covered every head. It will be very difficult to do so, but I've done the best I can to give you the basics in a short period of time. Those are my contact details if you've got any questions you want to ask me directly. Otherwise, I've got at the end my clerks. So if you have general inquiries, please approach them. And thank you for listening.